No, I've stopped dressing up for Halloween for a long time now. I'm sure it is. Yeah. Well, I'm certainly old enough. That's no, that's not Marshall though. They didn't wear the powdered wigs. They didn't have the colorful robes that they do in England. Hello, everyone. Can you hear me at home? Okay, good. No, John Marshall did that. Okay, guys, let's get started. We have a busy day. They're all busy days at this point. Today we're going to start economic due process, sometimes called substantive due process, and sort of the economic side of fundamental rights and discrimination, okay? And that's the two biggest, parts of the 14th Amendment are sort of fundamental rights and discrimination, as well as we've learned in the last class, the Fifth Amendment in regard to incorporation. So let's get going here. We have two eras, and arguably we might be entering a third era in regard to economic due process. What we have is the so-called Lochner era, based on the case of Lochner versus New York, a 1905 case, decided right in the middle of the laissez-faire economic movement. And you all know already what effects that has had on Supreme Court jurisprudence. And that went once again up until about the mid-1930s, 1934, 1935. Believe it or not, it started to change before 1937, which in other cases seems to be a magical year. So the Lochner era embraced laissez-faire, and it focused on the right, in the employment context, the right of the employer and the employee to enter into a contract. And it essentially called the right to enter into a contract a fundamental right. And therefore, state governments should not be interfering with the private right to contract. And what it essentially did was apply a strict scrutiny standard and second guess all the policy legislation that the states had done. So again, this was, sort of fashioned around the whole notion of laissez-faire that dominated at the time. Beginning in 1934, the Nebbia case, which we'll discuss briefly in a little bit, started to move away from viewing the right to contract as a fundamental right and started to move towards giving state legislatures more deference and not really second guessing the state legislators. The West Coast hotel case would follow. And then after that, the Caroline case would follow. And then finally, we'll conclude by sort of cementing this with the Williamson versus Lee optical case, a very, very important case for you folks on the bar exam. So I'm going to highlight that case in particular detail, okay? So what the Supreme Court started to do beginning in 1934 was to drop the standard for economic due process from enhanced scrutiny, from strict scrutiny, down to rational basis. We're going to defer to state governments, not interfere with their policy decisions, as long as they can show some rational basis. We'll see this is really, really a deferential test when it comes to economic due process. Um, essentially, even if we disagree with what they're doing, they're the legislature, they get to make the policy decisions. Let's uh, one further point is I think the post-Lochner approach is a pretty firm embracement of the concept of separation of powers. And we've been talking about this throughout this course. Uh, Legislatures pass laws. They deal with policy issues. The courts don't deal with policy issues. The courts interpret the law and specifically interpret the Constitution. The legislature should be dealing with economic issues because they're policy issues rather than the Supreme Court. If to the extent that the Supreme Court is dealing with policy issues, it is making itself a super legislature in violating separation of powers principles. On the other hand, if it's an important constitutional matter, like equal protection or like real fundamental rights that are called for in the Constitution, then at that point, it's law that the court is dealing with. And the court should be dealing with those things and not giving a lot of deference to the legislature. And that's essentially the reason why we have our three-tier scrutiny that we have today. And you're going to see that in these individual rights, sometimes there's a three-tier scrutiny, sometimes there's a two-tier scrutiny, okay? And there are slight differences behind the types of scrutiny that we give, but it's more or less pretty. It's based on the same concept. So the Lochner case, as I mentioned, is here for historical purposes. No one should graduate from law school without knowing what the Lochner era was. It comes up all the time when there are Supreme Court nominations, and you listen to the testimony of the nominee, or at least it used to come up all the time. Now, for a long time, the nominees just don't say anything anymore. They avoid answering any questions, essentially. Here, I guess being a baker is not a healthy profession. Flour dust can be very fine. Flour dust can get in the lungs and cause irritation. I guess bakers have a history of health problems. So New York passes a law that prohibits bakers from working more than 60 hours a week. Wow, that's a long week. That's almost as long as a lawyer works, by the way. But lawyers get paid a little bit better than bakers get paid. No more than 60-hour weeks and no more than 10 hours in any given day. Okay, and so Lochner violates this. He obviously, without the need to pay overtime, there really were no overtime laws back in 1905. He seems to be pushing his bakers right to the limit, making them work more than 60-hour weeks, not paying them overtime. He gets cited for violating this law, and he challenges it. He appeals, and the case eventually makes its way up to the United States Supreme Court. And here we go. The Supreme Court overturns the New York law, proclaims that the statute necessarily interferes with the right of contract between the employer and the employees. Some fairly strong language here. There's a limit to the exercise of police powers by the state. Is this a fair, reasonable, and appropriate exercise of police power? Or is it an unreasonable, unnecessary, and arbitrary interference with the right of the individual to his personal liberty or to enter into those contracts in relation to the labor which may seem to him appropriate or necessary for the support of himself or his family? Notice how they're shifting this on the employee is the one that's harmed by this. Without really even considering that maybe the employee doesn't have much choice in it. So this act is not a health law. It's an illegal interference with the rights of individuals, both employers and employees, to make the contracts regarding labor upon such terms as they may think best. You guys studied adhesion contracts in contracts, right? Kind of similar to an adhesion contract. If there's no regulation of the workforce, then the employers always kind of get their way. That's what laissez-faire was all about, really, was protecting the employer and not allowing interference. So 29 years later, Nebbia versus New York comes down. This case is intertwined with the New Deal. We've had multiple cases that are New Deal era cases from the 1930s. This one is no different. We already talked about some of the economic quotas that were imposed. Quotas such as you can't grow more than a certain amount of acreage, an attempt to keep prices up. Here, Nebbia owned a grocery store, and there was a New York law that required him to sell above a set minimum price. And he sold below the minimum price and was charged with breaking the law. When I first got out of law school, this is done a lot in Massachusetts in the liquor industry. In Massachusetts, in the liquor industry, at least back when I used to do this kind of licensing law, when I worked in Boston, in Massachusetts, it's illegal to sell an alcoholic beverage product for less than its cost, less than the retailer had to pay for it. I don't know what the policy for that was, but that was the law. In the ABCC, the Alcoholic Beverages Control Commission would actually send in investigators to liquor stores, to package stores, to purchase items that they knew were below cost. They had a list of how much it cost, and they pretend they were customers. They come in and they purchase the item, and then as soon as the cashier checked them out, they would then give a citation to the cashier for selling an item below cost. So I assume that's the same type of thing that happened here. Someone went in, bought the milk. The milk was below the minimum price that could be charged, and Nebbia is charged with violating the law. And here, probably an economic consideration to keep the industry, the dairy industry, profitable so that dairy farmers can make a living, and the like. And I'm sure some other policy reasons are behind it. But here is the court starting to erode the Lochner era analysis. Neither property rights nor contract rights are absolute. Government cannot exist if the citizen may at will use his property to the detriment of his fellows, or exercise his freedom to contract to work them harm. Equally fundamental with the private right is that of the public to regulate in the common interest. We find no basis in the Due Process Clause of the 14th Amendment for condemning the provisions of the Agriculture and Markets Law here drawn into question, okay? Now, this trend continues in West Coast Hotel Company versus Parrish. Poor Ms. Elsie Parrish, Mrs. Elsie Parrish, is what was then called a chambermaid. I guess we just call them room service attendants or something today. We don't tend to call them chambermaids. Like we don't call, they're not stewardesses or stewards on airlines anymore. What are they? Flight attendants. They're now called. So in any event, Elsie Parrish is a chambermaid working in this Cascadian hotel, which is owned by the West Coast Hotel Company. A state law said that she was entitled to a whopping $14.50 a week for a 48-hour week. And if she's paid anything less than that, then that would violate the minimum wage law. The so-called Industrial Welfare Committee and Supervisor of Women in Industry created this minimum wage. The trial court ruled for the defendant, obviously applying the Lochner era standard. Washington Supreme Court reversed. The case goes up to the U.S. Supreme Court. U.S. Supreme Court rules that the Constitution permitted the restriction of liberty of contract by state law where police power is being exercised, where it's for the health and safety of vulnerable groups. The state is making policy decisions here and clearly is moving away from Lochner. Caroline Products comes along, and now we're really getting the standards are coming down. In 1938, the Supreme Court is not just saying we're not going to consider the right to contract to be a fundamental right. They're actually, in this case, giving us some standards. This is referred to as the filled milk case. Filled milk sounds gross to me. When I was a kid, I grew up in a lower middle class family. We used to drink skimmed milk, but it came in a box and it was powder, and my mother would add water to it and stir it up, and it was pretty disgusting. It wasn't anywhere as good as whole milk, but it was affordable. Here, apparently, to make the milk more affordable, the companies would take the fat out of it, use the fat for other reasons, probably for cream or whatever, and then add some non-dairy oil to it, hence the name filled milk. So you might get animal oil or some type of vegetable oil that was added to the milk. And the federal law actually prohibited the shipping and interstate commerce of filled milk. Caroline Products complained that this was unconstitutional. It violated the Commerce Clause and also the right to private contract and property rights. It's an economic regulation. The Caroline Court says because it's an economic regulation, it is entitled to a presumption of constitutionality. In other words, the court is saying it will give deference to the legislature, okay? It's presumed to be constitutional. This is essentially a legislative judgment, not one for the courts. And he applies what is starting to sound like a rational basis review. The law was supported by substantial health evidence. Therefore, we're not going to overturn it unless it is arbitrary or irrational. In footnote number 4, footnote 4 is, some people say, the most famous con law footnote of all times. This footnote is a precursor back in 1938 to what is to come. We really don't have the tripartite standard of scrutinies that we've talked about starting back with the 11th Amendment. We don't have strict scrutiny, intermediate scrutiny, and rational basis scrutiny at this time. The court hasn't set down actual tests yet. Footnote 4, however, is a precursor. It is pointing out that, you know, in some cases, instead of applying this minimum level scrutiny, rational basis review, like we do in economic cases, in other cases, a heightened form of scrutiny will be required. It's not the case that it applies here, but here's what he says. He says, legislation aimed at discrete and insular minorities who lack the protection of the political process should be an exception to the presumption of constitutionality, and a heightened standard of review should be applied. And hence, coming out of this footnote 4 is, what's the enhanced scrutiny? Race, national origin, alienage, gender, fundamental rights. And economic rights are not fundamental rights, okay? So rational basis review is going to be discussed thoroughly in the next case, the Williamson versus Lee optical case. Here is what the plaintiff has to prove in rational basis, and we've discussed this already. The state has to have a legitimate purpose, and that legitimate purpose must be reasonably related to achieving that purpose. The law must be reasonably related to achieving that purpose. And we'll see how much discretion is afforded in the case of Williamson versus Lee Optical. I'm going to stop here, and I'm going to admonish you for a second to pay attention to this case. I can promise you this case will be on the bar exam, okay? It's not going to be the exact same facts, but it's going to be close enough for you to recognize it, okay? It's going to deal with a profession just like Williamson versus Lee Optical deals with a profession. So you guys know there are 3 levels of people who take care of your eyes. The head honcho, the top of the food chain, is the ophthalmologist. That is a medical doctor. The ophthalmologist can prescribe medications. The ophthalmologist can perform surgery. Next down is the optometrist. The optometrist can examine eyes, but can't prescribe medications and can't perform surgery. And then at the bottom of the food chain is the optician. This is the lens grinder, the guy who, as we know it today, takes the prescription that the optometrist or ophthalmologist writes, brings it to the optician, and the optician will grind the glasses, fit them into the frames, and make sure that they are, correct. Sort of the mechanic of the deal, so to speak. So apparently, in Oklahoma, opticians are performing the whole function. They're doing eye exams. They're essentially creating a prescription as to what kind of lens correction is needed. And then they're grinding the glasses and selling the glasses. You can get a pair of glasses without going to an optometrist or an ophthalmologist in Oklahoma. In 1953, Oklahoma changes the law. It says an optician cannot dispense glasses unless he gets a prescription from an optometrist or an ophthalmologist. And the optician challenges the law, okay? Now, this is clearly done for health, safety, and welfare reasons. It's a matter of policy. It's an economic or social policy that we're talking about here. It doesn't involve race, national origin, alienage, gender, or a fundamental right, because economic interests are no longer a fundamental right. We'll see later on, there's an argument that it discriminates on the basis of economics or status in violation of the Equal Protection Clause, but it's a losing argument, okay? Because you're allowed to discriminate for some reasons under the Equal Protection Clause. So again, look at this fact pattern. It's going to be a regulation that regulates a profession. It may not be opticians and optometrists. It may be psychologists and psychiatrists, okay? It'll be some other profession. It might be teachers. But there's going to be a regulation. And watch how strong the language is here. Watch how deferential. In these economic due process cases, the state almost always wins, and the plaintiff almost always loses. Justice Douglas writes the decision of the court. The law need not be in every respect logically consistent with its aims to be constitutional. It is enough that there is an evil at hand for correction, and it might be thought that a particular legislative measure was a rational way to correct it. The day is gone when the court uses the due process clause of the 14th Amendment to strike down state laws regulatory of business and industrial conditions because they may be unwise, improvident, or out of harmony with a particular school of thought. You see what he's saying here? He's saying, even if we think they're wrong, if there's a conceivable, rational basis that's justifying this, we are not going to get involved. We're a court, not a legislature. Policy matters, economic policy matters are left to the legislatures, not the courts. Do you guys see this as a separation of powers analysis that's going on here? Okay. All of the scrutinies that we're talking about, strict scrutiny, intermediate scrutiny, rational basis scrutiny, are reflective of the court's notion of how separation of powers should work, okay? They're trying to respect the doctrine of separation of powers. If there is a single conceivable justification that is based on logic, even if it fails to cure a substantial part of the problem the law is aimed at, and even if the court disagrees with the legislature's approach, it is going to be upheld. Furthermore, a law doesn't have to tackle all of the problems at once. Okay? It doesn't have to be a perfect fit with the problem. It can take incremental steps towards repairing the problem. Okay? So I promise you this will be on the bar exam. Is that enough to get your attention? Okay. Lochner Revisited. Since 1996, a couple of cases in the Supreme Court indicate that part of the court might be stepping back towards Lochner. The first case is the case of BMW of North America versus Gore, a 1996 case. By the way, it is not that Gore. It is Dr. Ira Gore instead. That Gore wouldn't drive a BMW. Doesn't he drive a Prius? I would say the guy who ran for president, right? And this is a case about a BMW. The plaintiff, Dr. Ira Gore, bought a new BMW. He later discovered that it had been repainted and apparently had been damaged during shipping between the factory and the car dealer. And this was not disclosed to Dr. Gore, and he bought the car as if it was a new car, and then was a bit outraged when he learned that it had been damaged previously, and he thought it shouldn't be considered to be a new car. BMW insisted that he had no remedy against it because they had a policy that if a car is damaged in transit and it can be fixed for less than 3% of the cost of the car, it will be sold as a new car. So he sues, claiming that this is a consumer protection violation. The state jury awarded him $4,000 for the diminution in value of the car because it had been damaged versus a pristine car that hadn't been damaged. And then some states allow punitive damages. You guys have had torts. You've talked about punitive damages. I'm sure you've talked about compensatory damages, nominal damages, punitive damages. Sometimes compensatory damages are actual damages. They award $4 million in punitive damages through a remitter. The court lowers the amount to $2 million, but leaves those punitive damages intact. BMW appeals. Case goes up to the Supreme Court. Justice Breyer writes the decision for the Supreme Court, and what does he find? Excessive state punitive damages awards violate the substantive due process clause, okay? And by the way, I'm saying substantive due process to distinguish it from something we will just barely touch upon in this course near the end, called procedural due process. Procedural due process is that you're entitled to a hearing before they execute you. And the hearing has to be essentially, and I'm just not talking in the criminal sense, also in the civil sense. The hearing has to be fair, essentially under sort of normative standards of fairness. Here, it's a much more subjective, as we can see, a much more subjective inquiry as to whether there's a violation of substantive due process. So the court is saying punitive damages may be grossly excessive, and then goes on and gives us a test. And this is the test that we have today when it comes to punitive damages awards. You have to look at three things. And then there's going to be a fourth thing added on in the next case, the State Farm case, that we'll do in just a minute. The degree of reprehensibility of the defendant's conduct, the ratio of the compensatory damages award, and the comparison of the punitive damages award in civil or criminal penalties that could be imposed for the comparable conduct. Okay, so here, if BMW had been charged with fraud, the court says that under this last one, greatest criminal or civil sanction they would have faced was $2,000, substantially less than the $2 million punitive damages that were awarded. And under the second category, even if you use the actual damages award, that's only $4,000. Again, substantially less. Now, some people would believe that BMW's conduct was fairly reprehensible. I would submit to you a similar case is the O.J. Simpson case that involved punitive damages. Not similar, I mean, obviously that case involved the murder of two people, the brutal murder of two people. O.J. Simpson was whacked with a $25 million punitive damages award. And the court, the jury found that the actual damages were half that, 12.5 million. So we don't have quite that disparity between the actual damages. While we do have the reprehensibility is substantially heightened in the O.J. Simpson case. Okay, Justice Antonin Scalia dissents. I think that Scalia is basically seeing this as an interference with the notion of separation of powers that we have just been dealing with. In the first paragraph of his dissent, today we see the latest manifestation of this court's recent and increasingly insistent concern about punitive damages that run wild. Since the Constitution does not make that concern any of our business, the court's activities in this area are an unjustified incursion into the province of state governments. And that's Thomas is on board with that, and actually Justice Ginsburg was on board with that. See what I mean? Ginsburg was obviously quite judicially liberal. Scalia obviously quite judicially conservative. The law makes strange bedfellows, and it's not the same as political liberalism or political conservatism. So don't equate the two. Here's the State Farm Mutual case. Curtis Campbell caused an automobile accident. A person was killed, another was permanently injured. He had a $50,000 policy limit with State Farm Mutual. You guys, I hope you know from torts the way that insurance policies work. They work through subrogation, essentially. When you buy an insurance policy, the insurance company is agreeing to cover you even if you're at fault. But if the other guy's at fault, it's going to pay you anyways. And then by the act of paying you, you assign the right to the insurance company to go after the person who caused the harm. They'll go after, not in their own name, but under your name. And the insurance company will try to get reimbursed for it. But here, Curtis Campbell apparently is just totally and entirely at fault in this matter. He wants to settle for the policy limit of $50,000. The plaintiffs are willing to take the policy limit of $50,000. For some reason, State Farm Mutual wants to fight it instead. So it refuses to settle. It takes the case to court. It tells Campbell, don't worry, we're going to win. You got no liability in the case. Campbell's kind of shaking his head saying, what do you mean? I was at fault. No, we're going to beat this thing. And the jury comes back with a verdict of over $150,000. So you understand the position that puts the Campbells in is that State Farm pays the $50,000. The Campbells have to come up with the $100,000 themselves. By this point, State Farm must realize they screwed up badly. So they turn around and they pay off the entire judgment. They don't make the Campbells do it. But the Campbells nonetheless sue for emotional distress, bad faith, fraud, and the jury comes back and awards them $2.6 million in compensatory damages and $145 million in punitive damages. The trial court reduces that to $1 million for actual damages and $25 million for punitive damages. State Farm appeals, and the court just follows Bush versus Gore, BMW versus Gore. Adding one thing here to the second category. It says that it actually gives us a ratio here. Punitive damages should not exceed the compensatory damages by more than 6 times. I'm sorry, more than 10 times. It's got to be less than 10 times for them to be upheld. And again, those are the same criteria that we talked about before. Same dissents that we have before. This is a matter of state law. This, to the extent there are punitive damages, these are economic or policy concerns. These are best decided by state legislatures rather than the court. The majority sees it quite differently. The majority says these things are so excessive that they're essentially unfair. When they're unfair, they do violate due process standards. Okay. In this case, the State Farm case, insurance companies have more money than God, just a ton of money. And I think what the jury wanted to do here with the $145 million punitive damage award was to make it hurt a little bit for the insurance company. Even if they had gone 10 times the 2.6, or say 10 times the 1 million to 10 million bucks, that's just a drop in the bucket for these insurance companies. So I'm sure that was discussed in the jury room, and that's where they came up with the $145 million figure. They must have been shocked by what the insurance company had done and found it quite reprehensible. Okay. All right. That's the end of substantive due process. Remember Williamson versus Lee Optical? I'm going to get you on this on the exam. This is where I'm different from other professors here. You know what they do? They just screw you. Okay. You know what I do? I tell you how I'm going to screw you, and then I screw you. Okay. A substantial number of you are going to get this Williamson versus Lee Optical wrong.
I think that's worse.
You're going to say something like, oh, there's a right to earn a living, or something like that. Okay. If it's a police power regulation, it's an economic consideration, there is no fundamental right, The standard is rational basis. Any conceivable rational justification will satisfy it, even if the court would disagree, okay? So watch for this. I don't take pleasure in saying, see, I got you. My mask is hiding my smile right now. Malaguti is nothing but a sick little man, just so you know.
We know that already.
I know. Not as bad as Rodriguez, I'm hearing. Okay. This is the contracts clause now. I'm going to go through this fairly quickly. You'll probably get a short question on this on the exam, not more than one. It's not tested with great frequency on the bar exam. It is occasionally tested, but it is not tested with great frequency on the bar exam. I'm going to sort of go through a couple of the major considerations that you have to take, do a few cases, and then we'll move on and spend the rest of our time in the takings clause, okay? Because you will definitely get a takings question on the multi-state bar exam. So the contracts clause is in Article 1, Section 10. No state shall pass any law impairing the obligation of contracts. So apparently during the era of the Articles of Confederation, states would relieve influential persons from their obligations to pay their debts. So if someone who held a lot of sway in a state had signed a promissory note and then defaulted on the promissory note, the legislature would pass a law saying that that contract entered into by the creditor and the debtor is hereby abrogated, and relieve the guy of the debt. And of course, the person who lent the money would be screwed. And so the framers of the Constitution wanted to prevent this from happening, and hence it created the contracts clause. Notice these words, they're important. No state shall, okay? Now this word impairing contract is going to be read by the Supreme Court to require more than a relatively minor impairment. It would have to go to the very heart of the contract to be actionable. And most of the time, the person claiming that the state has exceeded its authority loses on these cases, okay? The federal government has the right to impair contracts. The contracts clause, no state shall, does not apply to the federal government. It does not apply to Congress. It only applies to state legislatures, not the federal legislature, okay? So it's got to be a state or a political subdivision of a state, a municipality or a county. Here's the big thing that they test you on a lot, is that the contracts clause only applies to existing contracts, not future contracts. So if there's an existing contract and the legislature passes a law that relieves one of the parties of its obligation under the contract, then that would be a violation of the contracts clause. But what the legislature can do is pass a law that says no one in the future shall have a contract that does this, okay? So it can prevent people from entering into typical, particular types of contracts, okay? So it's only looking at existing contracts, and it's only a state that can be in violation of the contracts clause. So here's your methodology that's going to come out of the cases. So this is the slide that you want to memorize for the exam. You guys know that all of these PowerPoint presentations, all of these slides are preserved in perpetuity, or at least for the rest of the semester, on TWEN, right? So you can go back and look at these at any time. I've also put up a significant amount of materials on the TWEN site as well. There's a student study guide, there are methodologies that are up, There's an outline, an outside outline. That's a pretty good outline that I have up there. So there's plenty of stuff for you to use in order to learn this stuff.
Is that number 41? Just making sure. Yes.
What, this slide? Yeah, that's slide number 41.
Okay. Thank you.
So you can't be a lawyer if you don't know the law. So please, that's step one, is knowing the law. Step two is doing the proper analysis. Okay, so we're going to break these into two categories. If a state interferes with a private contract, or if the state interferes with a government contract, okay? Most of the cases are when a state interferes with a private contract. The government contracts are few and far between. If the state interferes with a private contract, there's essentially, the court doesn't call it this, but there's essentially a rational basis test. I wish the Supreme Court would have a more particularized test here, you know, like we just discussed. It gives us language that sounds like rational basis, but doesn't come right out and say it, okay? So one, determine whether a state law or regulation constitutes a substantial impairment. Notice how the word substantial is essentially written into the contracts clause. Two, determine whether the state has a significant and legitimate purpose for the regulation. Now you're setting up a balancing test, aren't you? Three, once a legitimate purpose is established, inquire whether the state law is reasonably related to achieving the public purpose. So the individual contract will yield to a valid state goal, okay? And the courts are going to defer to legislative judgments in this regard. This is not the case if the state is interfering with a government contract. Now we're applying a heightened scrutiny test, okay? And again, there's not a super particularized definition of what kind of scrutiny it is, but the court will focus on whether the state's interference was necessary and whether it could have used a less restrictive alternative, where it could have taken sort of smaller steps in order to do it. So here, it's likely that if there's an interference with a government contract, that the contracts clause will be applied and the act will be declared unconstitutional, okay? Our first case right out of the Great Depression kind of reminds us of being in a pandemic, quite frankly. If you live in Massachusetts, you know that there were moratoria on evictions for tenants who can't pay their rent, and there were moratoria on mortgage foreclosures as well. And you know, this is the worst economic times since the Great Depression. It literally is the worst economic times for a lot of people since the Great Depression. So a lot of states like Massachusetts has come in and created these moratoria. This happened in 1933. Minnesota did this. It created a legislative moratorium on mortgage foreclosures. The mortgages were already in existence. Are you thinking contracts clause? Here's what's lining up with me. Is a state that passes a law that allegedly interferes with an existing contract, right? A mortgage loan. You'll see in property class that a mortgage is actually a two-part transaction, one part contract, that's the promissory note, one part real estate interest, that's the mortgage, okay? It doesn't, the law doesn't come out and say that the mortgage is erased. What the law does come out and say is that you can't foreclose for some period of time, okay? And kind of like what happened in Massachusetts, the statute empowered extensions to the period here. So the Supreme Court upholds this law. First of all, it gives us this fancy language. It says that, you know, this is a time of emergency, but emergency does not give enhanced power. So you still have to follow the Constitution, you still have to follow the law. But then it goes on to say, however, emergencies are when legislators exercise power. Emergency may afford a reason for the exertion of a living power already enjoyed. So the court here is kind of being a little bit defensive, saying it's not just what some might say, ignoring the contracts clause because we're in the middle of a Great Depression. These powers are there. It's just that the Great Depression has given a reason for exercising powers that were already there. Um, uh, in Macbeth, of course, there's a line, the lady doth protest too loudly, methinks, right? So people who protest too much are often the people who are really being defensive and trying to hide something. So the court, emphasizes this is not a case where there's a repudiation of debt of a debt that would be going too far. A temporary restraint on enforcement, consistent with the spirit and purpose of the constitutional provision, and thus will be found to be within the range of reserved power for the state to protect the vital interests of the community. It was focused on the temporariness of this. And again, I'm saying the language here seems to point to a rational basis review. Legislation is addressed to a legitimate end. The relief afforded was justified. The condition imposed was reasonable. The measure was temporary. Okay. Here's the standard that I just gave you back on slide 41. It comes out of Energy Reserves Group versus Kansas Power and Light Company. Here, the Kansas Power and Light Company enters into a contract to provide natural gas within the state. The contract says if the federal regulators fix a higher price than is specified in the contract, the gas utility company can raise its price in a commensurate fashion. Sometime later, the state of Kansas adopts a law that says, no, the price of gas under a contract cannot be increased because a price is set by the federal authority. Kansas Power and Light challenges this, saying that it substantially interfered with the contract. The court here concedes that the contracts clause is facially absolute, just as the First Amendment right of free speech is facially absolute, and the right to free exercise of religion is facially absolute. I hope you're going to realize this fast. There is no such thing as an absolute constitutional right, okay? And I hope you're starting to see that there's always some kind of a balancing test. What's constantly going on here, you're going to see this for the rest of the course. We're going to be balancing the right of the individual against the right of the government, okay? The right of the government is usually a police power type right, the right to pass laws dealing with health, safety, and welfare. But sometimes those laws rub up against individual rights, okay? Interesting situation going on right now is going to be the question of vaccines, right? What's the government going to do when there's a COVID vaccine? We've got to get about 70% of the population to get immunity to this thing to put it to bed, but we've already got about 30% of the population being anti-vaxxers who don't want to take them. So what are we balancing? The right of the individual to be free from being told that he's got to take medicine he doesn't want to take. Arguably within the right of privacy, a fundamental right, okay? Balanced again against the right of the government to pass laws that benefit the health, safety, and welfare of the people. That's going to suggest a balancing test every single time, okay? Those who are strong believers in individual rights will fall on the side of the individual, and those who are strong believers in societal or communal rights will fall on the side of the government in these cases, okay? And we have a mishmash of opinions on the federal and state judiciaries in that regard. So the court here is telling us there's a balancing test. The more severe the interference, the higher the level of scrutiny. The court says, you know, this is a highly regulated area to begin with. The utility should have known what it was getting into. We have to balance the harm to the people of paying higher fees, you know, against the harm to the utility company to have its profits cut a little bit. So here the court finds no violation of the contracts clause, and again goes back and uses this test right here. Is there a state law or regulation that constitutes a substantial impairment? Does the state have a significant legitimate purpose for the regulation? Is the state law reasonably related to achieving that public purpose? Okay. The only modern case that finds a violation of the contracts clause in a private situation, okay? The Spanish case, 1978. So this corporation, the Allied Structural Steel Company, is an Illinois company, and it's got an office in Minnesota, and it gives benefits to its employees and provides a pension plan to its employees. And like many pension plans do, this one provides for vesting at certain benchmarks. You know, if you work for 5 years, you vest at this level. Another 5 years, you vest at a higher level. You know, you see these, for example, with public school teachers, okay? The longer you've been working in the school system, the more of your salary you're going to get at the end. However, the plan did have a termination provision, saying that the company could terminate the plan at any time. So after this pension plan is created through collective bargaining with the employees, Minnesota passes a law that says if companies terminate their pension plans, they have to pay a penalty to the state of New York. So Allied Structural Steel ends up leaving Minnesota, and as it's leaving Minnesota, it cancels its pension plan, and it's charged $185,000. The court sees this quite differently than it saw the Blaisdell case and even the Kansas Power and Light case. Here it says that the impact was severe, not just substantial, but severe. It modified the basic terms of the pension plan. And says, you know, there was no great emergency or no compelling public reason for doing this. Calls it a gross distortion of the existing contractual relationship and strikes it down as violative of the contracts clause, okay? We have one case where the contract that's interfered with is a government contract rather than a private contract. United States Trust Company versus New Jersey. This case has some history behind it. So the Port Authority of New Jersey and New York built roads. And in order to build roads, they borrow money in the forms of bonds, public bonds, municipal or state bonds. A bond is nothing more than borrowing money with a promise to buy it back. If you buy a U.S. savings bond, you're basically loaning the federal government money, and they're going to pay you back at a particular interest rate. Okay, and so when the bonds were negotiated, when the Port Authority was negotiating the bonds, it agreed in the bonding contract that it would use the toll revenues that are generated from the highways to secure the bonds, essentially. And it wouldn't use them for any other purpose. It wouldn't use them, for example, for railroad passenger service. Well, that's all well and good. 1962 was the era of the automobile. Big, heavy, gas guzzling automobiles that basically would tear up pavement as they drove down the road. All of a sudden, it's the 1970s, the mid 1970s, and we have the energy crisis in the 1970s, which most of you are too young to have remembered. I happened to get my driver's license when the speed limit was 50 miles an hour on all Massachusetts highways. The state had dropped the speed limit to try to conserve energy. Energy was hard to come by, and it was expensive. Back before the early 1970s, damn, we used to pay like 50 cents a gallon, I think, for gas, something really low like that. So in any event, the energy crisis comes, and all the governments start looking at mass transit as a way to deal with the inability to get all these oil products, these petroleum products. We would eventually find other ways to get petroleum, like producing more of it ourselves. Back then, we used to be totally reliant on the OPEC nations for petroleum. We're much less so today. So all of a sudden, the Port Authority wants to start using the toll revenues to build mass transit, to improve rail transit in and around metropolitan areas. U.S. Trust Company objects. It's obviously purchased a lot of these bonds. It wants them to be secure, so it claims that the Port Authority has breached its contract, and the court agrees. Okay, these are perfectly valid goals to want to support energy conservation, protect the environment, make sure people can still travel around while they're doing that. There's no doubting the legitimacy of these goals under the police power of these states. However, a state cannot ignore its financial obligations to pay creditors just because it would rather use the money to promote public good. Okay, and so the court strikes this down. It's an impairment that was not reasonable and not necessary. And it uses sort of enhanced scrutiny to do that. Okay, so there is our contracts clause stuff. I don't think I'll get through the takings clause today. I might get close to getting through it. We'll see. We've got about a half an hour left to go. This will be on the bar exam. This stuff is not all that easy in the sense of you don't have any real, well, you have a couple of easy tests, but you have one that's pretty difficult to deal with here. Do I have the, I didn't actually put in here what the takings clause says. It's so short that even I can remember it. The takings clause is the last clause of the Fifth Amendment. Fifth Amendment has a lot of stuff in it, okay? And the Fifth Amendment ends with nor, and I think I have this exact, if not, I might be off by a word or two. Nor shall private property be taken for public use without just compensation. Nor shall private property be taken for public use without just compensation. Okay. And once again, it sounds like it's fairly absolute, but of course, nothing is. Now, up until the early 1900s, the way the takings clause worked was that if the government wanted to take your property to widen a road or to build a building on that was necessary for use, clearly public purposes, then you had no choice in the matter. Government would come and tell you that it's taking your property. The legal word for taking is condemnation, okay? Condemnation is an eminent domain proceeding. And that's what just about everyone thought of. The government would come to you and say, you no longer own that. We're going to pay you just compensation. And then what they would try to do is screw you on the just compensation. They would give you something less than fair market value and force you to litigate with them. There are actually lawyers who do this as a specialty, who represent people who've had property taken by eminent domain, and they don't feel they've gotten enough for the property. What then started to happen, however, is that we started to get a highly regulated society. And to some degree, regulations intrude in my ability to use my land. So, for example, and I don't know, I can't even remember what the zoning requirements are for the piece of land that I live in. But it's fairly typical for zoning laws to have front yard, side yard, and rear yard setbacks. I can't build my house right up to the property line. I have to be, say, 40 feet back from the rear yard, 40 feet back from the front yard, and 15 feet or 20 feet back from the side yard. And then they tell me I can't, there are maximum areas. I can't build more than X percent of the area of my lot. Then there's a whole bunch of other regulations. Wetlands, we have wetlands behind our house, which is nice because no one's going to build back there. But at the same time, I can't put a pool in my backyard because it would be in the wetlands buffer zone, so to speak. So what are they doing? They're preventing me from using my yard to some degree. And so in the 1900s, people started to bring takings claims based on this. And they called them inverse condemnation. And there's a famous case, the Mann versus Pennsylvania Coal Company case, that Justice Oliver Wendell Holmes wrote. And he has these simple words, and the case is in your book. I don't even cover it because the only value of the case is these words: a regulation that goes too far is a taking, okay? So at some point, if these regulations unreasonably interfere with my ability to use the property, then I'm entitled to just compensation, even if the regulations are done for public purpose, okay? Now, that's not an easy call to make, is it? Can you see that? When does a regulation go too far? When does a regulation require just compensation? So once again, we have to go through a series of these balancing tests. And once again, do you see what? Get used to it. The right of the individual to be free in the use of his property and not have his property taken against the right of the government to zone, okay? And government zone for perfectly valid reasons, health reasons. When you build houses on top of each other, it's not healthy for people. For economic reasons. When you have houses that have nice yards, they're worth more, and you're going to pay higher real estate taxes to the town, and the town will be able to preserve its economic base, okay? Is another reason. Another reason why you want bigger lots and more valuable houses: you don't want everyone moving into your town all at once. What's going to happen if your town grows crazy out of control? Oh my God, the school system is going to be strange. Okay, when I was a very little boy, I lived in Burlington, Massachusetts, which was at the time one of the fastest growing towns in the United States. and the schools were going to go on double sessions. They would literally send some kids to school in the morning and some in the afternoon. So my parents up and moved away. But the idea is that was uncontrolled growth. Okay, so there's valid reasons for having zoning laws and regulations that prohibit these types of things. But at some point, if they're unreasonable, they're going to be deemed a taking by the court. And so what's on this slide, slide number 59, is what the Supreme Court has essentially done is break the analysis down into three categories, okay? The first is if the city or town allows the physical occupation of your property, that is a taking per se, a categorical taking. This is the best. Law students should love this one. You don't have to do any analysis. If there is a physical intrusion, taking, end of discussion, boom, okay? No balancing test. The second category, and the big case we're going to talk about is the Loretto case. The second category is the Lucas versus South Carolina Coastal Council case. If a regulation denies all economically beneficial or productive use of the land, it is the equivalent of a physical appropriation, and it's a categorical taking again, no analysis. So literally in Lucas, Mr. Lucas spends $1 million to try to develop a couple of parcels of land near Charleston, South Carolina that are on the waterfront. And the South Carolina Coastal Council passes these erosion laws that prohibit him from building at all. And the court says, taking per se. You've denied him all economically beneficial or productive use of the land. He can no longer do anything with that land, okay? Now, those two are the easy ones. Unfortunately, most of the cases fall into the third category, where there's neither a physical occupation nor a total economic or productive deprivation of the use of the land. I call these regulatory takings, okay? So here, less than a total deprivation, no physical intrusion, but still some inability to use the land as much as you want to use it. And this is the big case. The first case is the Penn Central case. And then this will get sort of refined with the Nolan, and I spelled that wrong there, by the way. There's 2 L's in Nolan. There we go. It's not the typical Irish Nolan that we know of in this part of the country. The Nolan and the Dolan case. This time Dolan is spelled correctly, okay? And we'll sort of refine this Penn Central case. Penn Central balances the burden on the private property interests against the governmental interest asserted. And, okay, talk about vague. Balance the private interest against the governmental interest. Can you give me a little more than that? And so the court does. The court says, when you're assessing the private property interest, you consider the distinct investment-backed expectations. So in other words, very often, the people are developing for the idea of making a profit. You see whether they can make a profit and how much of a profit they can make and how much this regulation interferes with profit. Against the legitimacy of the governmental interest, this is almost always going to be a police power interest. Health, safety, welfare, morals, aesthetics. Okay, that's the police power that we've talked about throughout the course. Okay, Nolan and Dolan deal with regulatory takings where the governments put conditions on licenses that you have to obtain to build or permits that you have to obtain to build. So before you can get a building permit, we're going to make you dedicate some of your land as a private park type thing. And so what these cases will tell us is that there has to be a nexus. A nexus is a relationship. There has to be a nexus between the legitimate state interest and the condition imposed by the government. Furthermore, it has to be a roughly proportional relationship, both in the nature and extent of the impact of the proposed development. So if there is a nexus between it, but they go way too far and make the conditions so onerous, it would not be roughly proportional, okay? So that's where takings gets mucked up, is in this whole regulatory taking thing. You'll be able to spot the physical occupation case pretty easily. You'll be able to spot the total economic deprivation case pretty easily. And then, you're going to have to know your balancing test, balance the investment-backed expectations of the individual against the legitimacy of the governmental goals that are trying to be achieved, okay? Two other things we'll talk about in this case. Actually, we'll talk about a third thing that I didn't get in here because it's a relatively new case. Can someone who buys the property after the taking has occurred challenge the regulation as a taking? Or is it just the person who owns the property when the regulation is passed? This is our Palazzolo case. You will see the answer is yes. There's no expiration date on the takings clause, essentially. And then if there's a moratorium that is done, is the moratorium itself a taking? And what the court tells us in this Tahoe Sierra case is that we apply the Penn Central balancing test to figure that out. And most of the time, it's not going to be a taking, is what we see. And a third thing I'm going to add is whether there's a taking, if it's a taking of private property, okay? And what the court has told us recently is that the takings clause applies to, I'm sorry, let me start that again, because I just totally messed that up, okay? The question is, does the takings clause only apply to real estate, or does it apply to personal property? And what the Supreme Court, all these cases are real estate cases, except for one that you're going to have. And in that one, the Supreme Court says the takings clause applies equally to personal property cases as well, okay? The case we have here involves raisins, believe it or not, the taking of raisins. One final thing we're going to look at is if it's two more things. If it's a taking, is it for public use? How do you determine if it's for public use? Got a couple of interesting cases. The Hawaii Housing Authority versus Mitkiv case and the Kilo case deal with this. And what we're going to see is that as long as the government says it's a public use, it's a public use. And then finally, how do you measure compensation? Is it the property owner's loss rather than the government's gain? Sometimes the property owner loses money when the government doesn't gain anything. And that's the rule, is that the property owner, it's measured by the loss to the property owner, okay? Not by the gain to the government. All right, let's start with, we're going to start with physical occupancy cases. This is the big case, Loretto versus Teleprompter Manhattan CATV Corporation, 1982 case. I don't know about you guys. When I grew up, there was no such thing as cable television. When I grew up, we had like 3 television stations. And you had either an antenna on the roof to get reception, or you had rabbit ears on top of the television to get reception. And I grew up with channels 4, 5, and 7. And then eventually they added PBS on channel 2. And then they added channel 38 and 56. And I remember someone saying, pretty soon, all television is going to come in through a cable. All reception is going to be through a cable. And you're going to have to pay a fee for it every month. And I said, who would ever pay a fee to watch television? You know, kind of like who would ever buy a bottle of water when you can go to the faucet and turn on water, right? Well, people have a lot more vision when it comes to business matters than I do. Now, most of us pay a couple of $100 a month to watch TV. I think we probably only pay more for the benefit of using a cell phone, quite frankly, if you have a family plan. So here, cable is coming into New York City, and what New York City wants is for everyone to have access to cable TV, whether they own the land or not. And so what they do is they pass a law that allows uh, uh, cable companies, cable providers, to install cable facilities on property, whether the owner wants it or not, essentially. And so Jean Loretto owns this building in New York City, and she's got some, it's not a huge building, it's big enough, and she's got tenants in the building, and she doesn't want cable coming to her property. But the law says you have to have it. Now, look at the intrusion on her property. It's fairly minimal. So there are these little eyelets, directional taps, that are 4x4x4 on the roof. The cable runs through them about 18 inches above. And there's a couple of boxes that are very small that are placed on the roof. And there's a wire running over and then a wire running down. She says, you have taken my property by passing this law, forcing me to have these wires and directional taps on my property. And she sues. And you know, the defense to this is, are you kidding me? This is such a minimal intrusion that first of all, you're not going to get much compensation. And second of all, it's not even a taking. It's such a minimal intrusion. Well, the court says, no, it's not, okay? And those of you who have taken real estate law know this already. The most important right that you have when you own property is the right to exclude others, the right to exclusive possession. We'll talk about that. And the court actually cites a lot of property law in this case and says exactly that. You know, the most important of all the property rights is the right to exclusive possession. No matter how minimal this impairment is, it is intruding on the right to exclusive possession, and therefore it is a categorical taking. We don't have to do any more analysis. It is a taking per se, okay? Now, Jean Loretto probably didn't get a whole bunch of money as a result of this. How much did this diminish the value of her building? You know, how much did this interfere with her use of the building? I'm sure, you know, you're going to find that she's not getting any less rent that she got before. Quite frankly, maybe the place is a bit more attractive to tenants who want cable TV and the like. But it's a categorical taking. Well, we have another categorical taking in Horn versus the Department of Agriculture. But this is the case, excuse me, that says that you can have a taking of personal property as well as real estate. So here, and I never knew this, the United States Department of Agriculture essentially forces raisin farmers and raisin distributors to turn over a part of the crop to the US Department of Agriculture every single year. And then the government decides what it's going to do with it. And this is part of the whole licensing scheme. Well, the Horns didn't like this. They thought it was unfair. And specifically for them, not only are they raisin growers, they're raisin distributors, and they handle raisins from other people. They pay for the raisins, and then they have to give some of it over to the federal government. So one day, the USDA trucks come to pick up their raisins, and the horns say, "Nope, you're not getting our raisins this year. We're not going to do it." So the government then assesses them the value of the raisins, $480,000, plus a civil fine of $200,000 for disobeying the order to turn them over. They went to the courts. They get up to the United States Supreme Court. This is clearly a physical occupation of the raisins, is it not? So it looks like it follows Loretto pretty straight. So what does the USDA say? Yeah, but this is personal property. Raisins are crops, they're goods. They're not real estate. The takings clause does not apply. The court says, we've never ruled that the takings clause does not apply to personal property. There's nothing in the takings clause that says it doesn't apply to personal property. And so we think it applies to personal property. So there's a categorical duty to pay just compensation if you're going to take these raisins. It should be the government paying the $480,000 for the raisins, rather than the horns giving the raisins over for nothing. Okay. A question, Teddy. Unmute yourself.
They didn't really explain why the government was taking the raisins just for holding them off for economic use. They didn't explain like the process, like what would they do with them? Just hold them off for emergencies. They didn't really explain that.
Yeah. So okay. Mute yourself again. Thank you. What's the process of the government taking the raisins? I don't know. I know that the government has oil reserves for national emergencies. I know that the government has wheat reserves for national emergencies if there's a shortage of food and the like. I know the government plans for this type of thing. I can't imagine there would be a run on raisins, and that it's as vital to have raisins as it is to have wheat and oil reserves and the like. I don't know. But apparently the USDA thought it was important enough to do. Now, what I'd like to know, the case is 5 years old now. What I'd love to know is whether the Department of Agriculture still has this, now that it has to pay for the raisins, whether it still does it or not. I don't know. I happen to like Raisin Bran, so raisins are important to me, but not to everybody.
Professor, I was just wondering whether that's the source the government uses to donate to food banks across the country?
Yeah, I mean, it might be. It might be, and I'm not suggesting that there's no valid government reason for doing it. And again, they do maintain reserves as well for not just for petroleum products, but for food as well. And I'm sure the government has programs where people who have trouble affording to be able to have proper nutrition are able to go to food banks and the like. Yeah, well, it depends on whether the president likes raisins or not, right? I mean, apparently Richard Nixon built a bowling alley in the White House because he liked to bowl. And then another president took it out. And it seems that, the presidents get some say in what they're going to do in the White House while they're there. Okay. Now on to regulatory takings. I'm not sure why he gives us regulatory takings, which I presented as the third category. I think that physical occupancy and total deprivation of economic use should go right beside each other because it's the same analysis, which is a per se taking, but the book doesn't present it that way. So Penn Central Transportation case versus New York. I should get a picture of this. Grand Central Terminal is in Midtown, New York. I bet you a lot of you have been there before. It is essentially South Station on steroids. People walk into South Station and they think it's big. It's not. Grand Central Station is huge, and it's quite a piece of architecture. The facade is 8 stories high. And see, I made another mistake here. Whenever you have a complex adjective, you have to put a hyphen between the 2 words. The facade is 8 stories high, and it's of the Beaux-Arts architectural style. And it's on the National Register of Historic Buildings as well. And so there's a big government, benefit in preserving these types of buildings. You're preserving sort of the culture of not just New York City, but also of the United States as well. Penn Central owns Grand Central Station. It's not just in the railroad business, it also is in the real estate business. And it owns a bunch of other hotels and buildings in New York City: the Barclay, the Biltmore, the Commodore, the Roosevelt, and the Waldorf Astorias. The Pan American building, that's on Fifth Avenue, if I remember. Yep, other office buildings on Park Avenue. So they want to come in and have rise out of the facade a high rise. And they want a big ass high rise. They want it to go way up into the sky. And the zoning seems to allow them to do this, except the historic commission that's running this comes in and says, no, if you do that, you're going to ruin the presentation of the Beaux-Arts architecture. You're going to dwarf the facade that everybody sees when they go into Penn Central Station. You're going to ruin the architecture if you do this. So we're not going to let you do this, okay? We're going to only let you go up so many stories, not all the way that you want to go, but so many stories. And in order to compensate you, we're not going to pay you any money for, the profits you're going to lose for going up as high. And to be clear on the question of profits, and this is what I think eventually does in the Penn Central Company, they're making a lot of profits from this. They're going to make profits from this. They're just not going to get all the profits that they wanted to get from this, because they're not going to be able to build as high. So what they say is, hey, if you want to do any other, additions or modifications on any of your other buildings that you have downtown, we're going to give you transferable development rights, TDRs, they're called in the land use business. And even though you can't extend those by zoning, we're going to give you the zoning that you lost here. We're going to let you apply it somewhere else. Pretty good gimmick for the city, isn't it? Because what are they doing? They're not paying any compensation. They're instead just saying, well, you can build somewhere else. Well, Penn Central says, no, that's not compensation. You're taking my property. So the question here is whether this is even a taking. And the court is dealing with this case where exactly how I kind of pictured it. You're not being told you can't build the building. You're being told you can't build it as high as you wanted to build it. Is that interfering with some of your use? Yeah, it is. But is it interfering enough with your use to constitute a taking of your property? So it's not the case where your property, they just come in and say, we're taking your front yard because we're widening the road. You can pretty much figure out how much the front yard is worth, and you can compensate for that. Here, you're just not allowed to build any higher, okay? So the court comes in and writes this decision and creates the Penn Central balancing test. The court must consider the economic impact of the regulation on the claimant, and particularly the extent to which the regulation has interfered with distinct investment-backed expectations. And the problem here is not very much. The evidence shows that Penn Central was still going to make a ton of money, just not quite as much as it wanted to. And this is balanced against the health, safety, morals, or general welfare promoted by prohibiting contemplating uses of the land. And you know where the justices are going to fall on these, right? Those who are for big government are going to be on the side of New York. Those who are for individual rights are going to be on the side of the individual, okay? Most of the time, the court takes the government side. Okay, now we get into our final categorical taking. Lucas versus South Carolina Coastal Council. I've already described this case to you. Lucas buys a couple of lots right in the waterfront, right near Charleston. If you've never been to Charleston, you want to go to Charleston. It's a great city. It's a very accessible city. It's a walkable city, and it's got good food as well, and it's warmer than it is here. But it's a hot city, so it's expensive to travel to. I bet you these days it's not. I haven't been on a plane since before the pandemic, nor do I intend on going on one anytime soon, to be honest. But it's a fun city to visit. So here, you know, this Beachfront Management Act essentially barred him from being able to put up any structures on the building at all. The finder of fact found that this rendered the property valueless. He sued, saying that it was a taking without just compensation. The court here says when a regulation denies all economically beneficial or productive use of the land, that is the same as when there is a physical occupancy of the land. It is a categorical taking. We don't have to do any more analysis. And let's end it right there with the Lucas case. I'm just about out of time. Okay. You guys have a good weekend. You stay safe. In all honesty, I don't know how much longer we're going to be doing live classes. You know, the numbers we're about 2 weeks behind Europe. And we're starting at a much higher baseline than Europe is. And it's going to be getting really, really ugly. So, you know, I don't know if we're going to be making it all the way through until the end of the semester.
We're not in the red yet, as far as I know, right? But we're in the kind of orange area for Massachusetts.
Yeah, well, we're not in the red on the 7-day rolling rates, but I think the last 2 or 3 days have been over 4%. So
Okay.
we are going up, and I think you have to go up for like 7 days in a row or something to get into the red.
A lot of cities are in the red though, Linda, so I think.
Yeah,
we're-
everyone's heading in that direction from what I'm hearing. So
Okay, thank you.
yes.
Thank you. Have a
Sorry
good.
to be the bearer of bad news.
Yeah,
That's okay.
we figured it, but we'll get there. Bye.